My name is Pablo de Jesus. I'm the Executive Director of Unitarian Universalists for Social Justice. And we're very pleased to have you. We're so proud to have this speaker with us talking about this important issue. We're deeply appreciative to Reverend Lisa Garcia Sampson and Donna Scheid and David Shilton and Fred Van Dusen and Becky Harper and Chris Shunton and April Harris. Friends in this struggle as we all get ready to listen to the arguments around this case on December 7th. I invite you to join me on the steps of the Supreme Court. I think that we're going to have a vibrant crew down there on the day that the oral arguments are going. And I just want to remind all of you, Unitarian Universalists and friends who are joining us, not necessarily Unitarian Universalists, that you have a friend in UUSJ here in Washington, D.C. Our interest, our ministry is federal engagement. And we want to help sharpen the UU denominational impact on federal policy and legislation. And so we invite you into a movement for that purpose. Please feel free to go to our website, uusj.org, get our e-news, sign up to take actions with us, become a member of our advocacy and witness lists, and get involved. Any given UU, any given congregation can do great work locally, but we need you to remember that we also need to be present doing the federal work, and that together we have far more power than we do alone. So in that spirit, I invite Reverend Lisa Garcia Sampson, one of my best friends in the struggle for justice among UUs, one of the very best executive directors that we UUs have at the state level, to open a sacred space for us and to center our thinking on the important matters of this evening.
Well, Pablo, thank you so much. Thank you, my dear friend. It's such a privilege to be here with you all tonight. As Pablo said, I'm Reverend Lisa. I proudly serve as the Executive Director of UU Justice NC. That's our UU Justice Ministry in North Carolina. And I have the privilege of opening this spiritual space tonight because the case that we will hear about tonight, this monumental court case comes out of my beloved state of North Carolina, and we know will have ripple effects across this nation. And so we kindle our flame, kindle this chalice, welcoming in the spirit of the great movement for liberation alive in our nation today. This is the call of our faith, to hold the vision of a truly equitable, multiracial democracy and living into that commitment. As we move into our time tonight, I was thinking about what I might need, what we might need to be fully present into the space, listening to our bodies, listening to our spirits just weeks after, just barely a week after the midterms, when we are still getting election results, when we are maybe writing postcards to Georgia while the work of affirming the sacred democracy is 365 days a year, and we probably feel that now perhaps more than ever in the course of our year. And so I want to invite you tonight to think about acts of resistance beyond winning and losing. We talk a lot about winning and losing, and it's important that we do, because court cases like Moore versus Harper will have serious ripple effects that will impact our country. But I want you all, as we listen tonight, to think beyond those wins and losses, and to think about all of the wins that build our movement. If you are tired tonight, I hope that you know deep in your bones that rest is an act of resistance, that self-care, that closing your eyes while you listen to this, while drinking a glass of water while you're present tonight, that is winning. whether or not we win or lose this case, we're going to give it everything we have. But the fact that we are here together tonight, I see our colleagues, our Jewish and Christian colleagues on this call tonight, our partners across our movement for justice, that is winning. The fact that we are tired in the first place because we have been giving our heart and soul to this democracy and to this election over the past weeks and months, that is winning. And so I want to affirm all the ways in which we contribute to movement tonight, all of the ways in which we are building something that no court case, no election result can ever take away. It is a movement for justice beyond our wildest imagination. And our faith calls us to believe in it and to believe in us. I want to close by inviting everyone, whether your cameras are on or off, to lift your hands up in a blessing to our amazing speakers tonight. Becky, you represent the best of our faith. We are so proud of you. And I hope you feel not only the people of our faith, but people across our country holding you in this work, affirming you, knowing that we have got your back. Chris, our beloved partner in this work, I hope you feel the deep gratitude and appreciation of all of us tonight. Our friends from Common Cause, our friends from the Center, the Coalition for the Southern Coalition for Social Justice. This family, this deeply interconnected family, you couldn't break from it if you tried. We are tangled up together. That is our Unitarian Universalist faith. And our deepening of relationship with you all is a blessing. And so may we enter into this moment with open hearts, with open ears, with kindness to ourselves, and above all, with gratitude and deep faith in what is possible when we come together on nights like this to affirm our belief in democracy. Amen.
Amen. Thank you so much, Reverend Lisa. And I do want to underscore one thing before I kick it over to Donna. We're about, the news has been rolling out this afternoon that the House has indeed flipped. And we are very likely to get a Speaker McCarthy. The politics on that will have to play out. But I invite you to join UUSJ to hear comments in early December from President Emeritus of Bread for the World, David Beckman. He's going to be speaking to us very specifically about what it's like to work for social justice in the federal context in a tough political environment. David has been a leader among nonprofits working in the faith-based social justice advocacy area for over 20 years. He's got an even longer history here in Washington, D.C., doing work around development issues. And I think it's really important for we as Unitarians to hear from folks like David who know and have been around the block politically and in terms of the policy about what this emerging landscape might have for us. Because during late December and January and into early February, that's the time that we have to be preparing for what's going to be going on in state legislatures around the country and in our national legislature. And divided government in this circumstance is going to be rough. And it's going to require that we are committed to the long haul, not the loophole. So I invite you to join us for that. It's a wonderful ticketed event with a sliding scale to guarantee access to anyone who wants to join us. I'll put details in the chat. But having said that, I'm now going to turn it over to Donna Scheid of North Carolina, a member of our Democracy Action Team, a wonderful and cherished brain, to introduce our lovely North Carolina speakers.
Thank you so much, Pablo. It's great to be here tonight, and we're so glad that you all could make it. I'm Donna Scheid, and I'm a volunteer with UUSJ and a member of UUSJ's Democracy Action Team. I have the privilege tonight of welcoming our speakers. Becky Harper is a board member of Common Cause North Carolina and a named party in the pivotal redistricting case concerning the balance of powers that we'll hear about tonight, Moore v. Harper. Chris Shenton is an attorney with the Southern Coalition for Social Justice who is representing on the case. Before we begin, I want to follow up with Reverend Lisa's beautiful space opening words with a few words myself, in particular about Becky, who I'm just meeting tonight, but who I adore already, and about living one's faith and values. You see, in addition to her role in this case, Becky is a longtime member of the UU Fellowship of Raleigh, North Carolina. And I, for one, am curious to learn more tonight, not only about the case, but about Becky as a fellow Unitarian Universalist. In a world increasingly divided by partisanship, by who plays for blue and what issues are thought of as red, I think of UUs as striving to work in the space of yellow. Yellow, the color of the flame, like the one that Reverend Lisa lit earlier tonight at the center of our chalice. Yellow, the t-shirts that proclaim side with love. So what do I mean by that in this context? I mean that there are principles and values that have guided us, that should guide us beyond who wins. And you'll hear some similar things to what Reverend Lisa was saying earlier. There are more than just rules of the game. There are rules of relationship, of how we choose to be in relationship with one another, not just interpersonally, but as a people, as a body politic. And these rules are fundamentally ethical. Some might say they are even matters of faith. For us as UUs and for our friends across other faiths, they include dignity, justice, equity, freedom, conscience, and dismantling racism and oppression. Yet these values are mere talking points, but for those in our faith who enact them by walking the walk, those who organize, those who serve, those who protest, those who advocate, those who witness, those who are willing to side with what they believe in, to commit their time, their resources, their private lives made public. And one of these, of course, is Becky Harper. As I understand it, serving as party to a legal case of the magnitude of Moore v. Harper is an exceptional act of witness and advocacy. It is an act of witness to this startling fact. Every election in North Carolina in the last decade was based on gerrymandered maps, maps drawn by the state legislature that were later ruled unconstitutional, either on the basis of race or partisanship. Computer-aided line drawing is the precision instrument of our age of redistricting that makes this age like no other, even in recent history. In other words, not only are the foxes in charge of the hen house, but they have the algorithms that can ensure that they remain perpetually in charge of the hen house. Furthermore, in North Carolina, the people cannot pursue state level referendum and the governor has no power of veto over legislature drawn maps. What does this mean? The courts are a singular recourse, an essential check in protecting the rights of the people to meaningfully choose those who represent them. Becky's role in this case and that of her lawyers is also an act of advocacy. They insist that in our United States, people should matter over politics. They insist that that fundamental system of checks and balances that our founders devised to protect our essential rights and liberties, including our right to choose who represents us, should endure. Make no mistake, this case will make history, and our political future as it either confirms or erodes the fundamentals of our political relationships. It is because of these stakes that UUSJ is pleased to have signed on as an amicus to Moore v. Harper and to welcome those here tonight who are so central to its outcome. I'd like to turn the floor over to our guests, Becky Harper and Chris Shelton.
Good evening, everyone. Thank you for those lovely introductions, and it's wonderful to be here among my fellow UUs and many of our supporters from other organizations. It's really an honor, and we are grateful. So my colleague, April Harris, is also online, and April is going to manage the screen sharing for the presentation tonight. April is on the staff of Common Cause North Carolina. So lots of people do ask how it is that my name ended up on this case, and I will talk a little bit about that as we proceed. Next slide, April. Common Cause has been around for decades. The primary goals and objectives that Common Cause has held are issues around campaign finance reform and fair redistricting. Common Cause North Carolina is one of the largest and most active Common Cause chapters in the United States. We are a nonpartisan organization, and we have a variety of activities and programs in North Carolina. This particular slide highlights something that I'm very proud of, which is our Democracy Fellows program. We now have Democracy Fellows. Common Cause North Carolina provides scholarship support to students on all 10 historically Black colleges and university campuses in North Carolina. Our fellows on the campuses organize, recruit their students to register to vote, to manage campaigns, to get people to the polls, to run educational programs, to many of them worked as poll watchers and poll workers in the recent elections. It's a very exciting program that Common Cause North Carolina has been developed and has been funding for many years. Next slide. So Common Cause has been the primary legal entity that has filed lawsuits regarding the gerrymandered districts in North Carolina. And as Donna so beautifully and correctly pointed out, districts in North Carolina have been badly gerrymandered for most of the last elections, and various elections have taken place under maps, using maps that were later ruled unconstitutional. We have a variety of partners in this work, and at various times, other entities have been co-plaintiffs in the legal actions. The League of Women Voters, the Southern Coalition for Social Justice, the Southern Environmental Law Center, and other groups have been parties to these lawsuits. Sometimes they file their own lawsuit, and then the courts amalgamate the cases. Next slide. So this is the most recent history of legal action in North Carolina. 2019 was a huge year because Common Cause case, Rucho v. Common Cause, went to the U.S. Supreme Court. And we were very hopeful in 2019 that the United States Supreme Court was going to adopt some standards regarding gerrymandering that would have been helpful to us here in North Carolina, but would have had impacts nationwide. What the court did in this case is they said that there really was nothing in the federal constitution that gave them guidance about what they could do on gerrymandering issues. There wasn't a standard that they could see adopting. And so they basically kicked gerrymandering issues back to state courts. They said that there may be things in state constitutions that address the subject of gerrymandering, but at the federal level, there was no way for them to issue a ruling. So in that, after the Rucho decision in 2019, Common Cause sued in state court, and that case was Common Cause v. Lewis, and the Superior Court ruled that the districts were gerrymandered and ordered new maps drawn, and then that there was a subsequent, that case morphed into it's complicated, but anyway, that case became the first case with my name on it, Harper v. Lewis, also in 2019. And in Harper v. Lewis, the North Carolina court ordered new congressional maps for the 2020 election. So you may recall there was a census in 2020, there was COVID in 2020, the census data was late coming in. A lot of states were scrambling over how to redistrict with late census data, et cetera. So the North Carolina legislature drew, again, extremely gerrymandered maps for Congress as well as for our legislature, which in North Carolina is called the General Assembly. And the other thing that happened in 2020 in North Carolina that was significant is that because of our population growth, we were awarded a new congressional seat. So for a number of years, we've had 13 congressional seats in North Carolina, but for the elections of 2022, we were going to have 14 congressional seats. So obviously that required new lines to be drawn for the congressional seats. So Lewis, who was the drawer of districts, Republican leader in the House, ended up losing his seat. So the next guy that took charge was another Republican legislator named Hall. So that case became Harper v. Hall. And that case went to the North Carolina Supreme Court. And remember that in Rucho, they had said it's up to state courts how whether or not there's anything in the state constitutions that impacts gerrymandering. So in Harper v. Hall earlier this year, our state Supreme Court said that the districts were partisan gerrymanders, not racial gerrymanders, but that the legislature had discriminated against people based on their beliefs, based on their political preferences. They had made it more difficult for people of a particular political persuasion to elect representatives that represented their viewpoint. And the state Supreme Court in North Carolina technically kicked it back to the Superior Court. But anyway, the courts adopted, they hired special masters, expert map drawers. Those map drawers presented a new congressional map to divide up our state into 14 new congressional districts. But the court did accept a modified map that had been drawn by the General Assembly for the General Assembly districts. Next slide. Next, yeah. So this is the map that the General Assembly initially brought to the initially adopted for the new 14 congressional districts in North Carolina. And this map, based on all the expert analysis, and unfortunately, we as voters, all of us are pretty predictable these days. So the likely outcome from this map in a purple state where the actual vote statewide is more or less 50-50 would have been 10 Republicans and 4 Democrats. Next slide. The North Carolina Supreme Court in Harper v. Hall ruled that it was unconstitutional and that it had deprived voters of their right to equal voting power on the basis of their party affiliation, on the basis of their political beliefs. Next slide. This is the map that the special master drew for the court and that the court imposed in North Carolina. This map, it was predicted to result in 7 Republicans and 7 Democrats being elected from North Carolina. And in fact, this is exactly what happened last week. So as a purple state, we have elected 7 Democrats and 7 Republicans to represent North Carolina in Congress. And the map, in fact, was a great success. This map was adopted for the 2022 elections only, and our General Assembly will have the authority to redraw the congressional map for the 2024 election. Next slide. So Moore v. Harper is is basically an appeal of Harper v. Hall. When that map was imposed by the North Carolina courts, the General Assembly was very, very unhappy. And they immediately appealed to the Supreme Court of the United States, and that case became Moore v. Harper. So at this point, I'm going to turn it over to Chris, because I am not an attorney, and I've been instructed by my lawyers to allow them to speak about the legal issues of the case.
Well, thank you so much, Becky. So my name is Chris Shenton. I'm one of the attorneys at the Southern Coalition for Social Justice. It's a pleasure to be with you all here this evening. So Becky teed it up beautifully. Don't let her fool you. She knows a lot about this stuff. That is exactly the right description of Moore v. Harper. So after the Superior Court in February of this year issued or implemented the remedial plan for the congressional map in North Carolina to be used in this election only, with the legislature to redraw for 2024 and beyond, pursuant, by the way, to North Carolina statutory law. The legislative leadership, I should say, in the North Carolina General Assembly appealed that judgment to the United States Supreme Court. They made that request on an emergency basis in February and on a regular basis in April after their request for emergency relief was denied. And on June 30th of this year, the United States Supreme Court granted certiorari in the case. And we have been briefing it all summer and fall and are set to go to argument on December 7th, 3 weeks from today, as many of you know. And so in the case, North Carolina's legislative leadership is arguing that the federal constitution has language in it that requires state legislatures to set federal election rules without regard to checks and balances contained within state constitutions. They argue that the federal elections clause means that state legislatures are solely empowered to set the rules for federal elections, regardless of limitations that may exist in state constitutions, regardless of limitations that may be placed on them by state courts, and regardless of limitations that may be placed on them by state executive and administrative agencies. So the legal theory is something called the independent state legislature theory. It's based on a literal reading of one small part of the Constitution and would have widespread consequences for a whole host of voting rights protections that have been found in state constitutions throughout history. State Supreme Courts frequently read their state constitutions to be broader than the federal Constitution, even when it comes to analogous language. Like many states, North Carolina among them, read their free speech and freedom of assembly clauses broader than the federal Constitution. Many of them read their equal protection clauses and brought more broadly than the federal Constitution. Both of those clauses were at issue in the state court judgment in February of this year. And both of those judgments are being challenged by legislative leadership at the United States Supreme Court. So just as some of the things that independent state legislature theory, if adopted by the United States Supreme Court, could affect, it could very well limit the ability of state courts to address partisan gerrymandering. It could limit the ability of state courts to enforce voting rights protections at all in federal elections. And it could make it so that state legislatures are able to change the rules completely divorced from checks and balances that may be found in those institutions and in state constitutions. It would make it easier across the country, not just in North Carolina, to gerrymander on a partisan basis, to create new barriers to voting access, to cast doubt on fair election results, and to really set the rules of federal elections without any regard to those checks and balances that we were talking about. So we look forward to presenting the case on December 7th. I promise you we're hard at work, and we will keep at it in the 3 weeks between now and then. And we're looking forward to presenting our case. I'll hand it back over to Becky to talk about what some of this means.
Thank you so much, Chris. So, as Unitarians, we're all involved in so many social issues, social justice issues. These are just some of them that I know that all of you are passionate about. For me, it has been clear for a long time that progress on most of the issues that we care most about is thwarted, largely thwarted by the issue of gerrymandering. Because when the people cannot elect representatives that reflect their values, when the people cannot choose their representatives, when in fact the system works backwards because the elected officials choose their voters instead of the voters choosing their representatives, then the causes that we are all passionate about are thwarted at the legislature. This is where elections are stolen. This is where election security really is threatened, because it reduces or eliminates the ability of the voters to make their wishes clear and to have people who reflect them in the legislature. As Chris said, in North Carolina, we have particularly unique issues because structurally in North Carolina, our legislature is very strong constitutionally. We have a relatively weak governor, and our governor has been made even weaker because the legislature took many powers away from the governor when before the current sitting governor took office. We elect judges here in North Carolina. We do not have the right to referendum and initiative, some of the methodology that citizens in other states have used to reform the electoral process by adopting independent redistricting commissions and other reforms. So our legislature is so very powerful compared to the courts are really, as Donna said, the courts are really our only avenue for relief here in North Carolina. In other states, other players have, for example, in some states, governors have the authority to veto redistricting maps. Not true in North Carolina, but it is true in other states. In other states, there may be elected secretaries of state that have prescribed constitutional responsibilities. A lot of those secretaries of state, of course, have been in the news a lot recently. we have a Secretary of State in North Carolina, but she has absolutely nothing to do with elections. So we have a different structure here, but in every state, there is a functionary, a Secretary of State, a Board of Elections, or something that has prescribed responsibility for running elections or for setting rules around elections. And all of those things could be affected by Moore v. Harper, depending on how the ruling comes down. So what we're doing here in North Carolina, Common Cause has been running an aggressive speakers bureau. We are talking to anybody that will let us speak to them. We have 100 counties here in North Carolina. We're trying to have events in all of them. We're doing a lot of Zoom meetings. Myself and other members of the board are having these conversations with people to let people know what this case is about and what the potential impact is, not only here in North Carolina, but nationwide, because the case will affect every state in the country in different ways. So we do expect a struggle here in North Carolina over the districts. As we all said, the map that's been adopted is only for this election cycle. It was a huge success. I'm proud to have my name on Harper v. Hall, but we just had an election which unfortunately did not go well in North Carolina. I know many of you on this call felt pretty optimistic about nationwide election results, but what happened here in North Carolina is that 2 of the Democratic members of our Supreme Court, who had in fact handed down the ruling in Harper v. Hall, they lost their seats on the court in the election last week. And unfortunately, more than $4 million was spent painting these judges as sympathetic to pedophiles, lots of ugly advertising on TV, and all of that advertising was paid for by redmap.com. We have a struggle ahead of us, and much of that struggle the rules of the road in that struggle may well be determined by the outcome of Moore v. Harper. Next slide. So we are delighted to take questions.
Yep.
Let me know if there's anything.
Thanks. So let me just hold some space here while the Q&A team gets ready and Paulette resets the spotlights. We're going to do questions and answers. We're going to be led by David Schulten, a member of our Democracy Action team in that, with Fred Van Dusen, also a member of our Democracy Action team, monitoring the chat. So we encourage you, because we're recording, to be brave, raise your hand, ask a question using your face. But if you are the kind of person who prefers to put a question in the chat, then please do that, and maybe put a Q and then a colon in front of it, so that the folks who are monitoring the chat can really zero in on those. So with that, I hand it over to David Schulten for our first question.
Great. Thank you, Pablo. And thank you so much, Becky and Chris, for that wonderful presentation and for all the terrific work you're doing. Very grateful for that. And while we're monitoring the questions coming in, I have one of my own for either of you. And that is, the independent state legislature doctrine, I think, has always been looked at as kind of a bit of a crackpot doctrine, and I don't think was taken very seriously for quite a while. And second, given that the Rucho case said, well, federal courts can't resolve these gerrymandering cases, but you've got state constitutions and state courts that can do that. How in the world did the Supreme Court get 4 votes to grant review in this case? And what does it say about our current Supreme Court that they seem so interested in taking this step, which seems so backward?
That would be a question for Chris.
Sure, I can take that. The first question first. So the independent state legislature theory has been around for a while, and it has been pretty much uniformly rejected by federal courts that have heard it for over 100 years. And that's something that we lay out in the briefing. We go through the history of that case law and sort of walk through all of the different challenges that have presented versions of this theory, and in our briefing argue that they've had it right, and they've had it right for a while. And so that's a big portion of our case is laying out all the times that federal courts have considered similar versions of this argument and have thus far declined to adopt them. And so that sort of ties into the second question, I think, which is, again, a big part of our briefing. In Rucho, Chief Justice Roberts said, federal court is not the venue for you, but state courts and state constitutions can offer standards and provide remedies for partisan gerrymandering in a way that we can't do here at the United States Supreme Court. And so Common Cause and Becky took John Roberts at his word and said, okay, we'll go to state court. And we've done exactly what you asked us to do here. And yet we find ourselves in front of the Supreme Court again. So that's something that we've also made a big centerpiece of our argument. In terms of the kind of specific mechanics of how we were granted certiorari, it is an issue that has come up with kind of increased regularity in recent years, particularly in 2020. We saw this theory being raised a lot in litigation immediately following the election, in a lot of the cases that were challenging the results of that election. And various justices on the Supreme Court currently had written at various times saying, well, this issue keeps coming up, and so we think we should probably resolve it. And we think that probably has a lot to do with why we're presenting our arguments 3 weeks from today.
Great, that's helpful. And this is kind of a related question, really, from Marilyn. And I know it's hard to make predictions like this, but she asked, what are the chances of our side prevailing in the Supreme Court on this case?
I don't want to prognosticate. I know we're working real hard at presenting the best case that we can, and we feel good about our case, and we're looking forward to bringing it. And can't say too much more than that, but very much believe in our case, and really looking forward to presenting it to the current Supreme Court.
I would just like to chime in, for your exciting bedtime reading, all of the briefs are available on the Common Cause website. And it's a who's who in terms of amicus briefs, cutting across the political spectrum. Arnold Schwarzenegger has weighed in on my side. So how about that? And J. Michael Ludig, who you may have seen on TV in the January 6th hearings, and who is considered one of the most conservative justices. He was many times considered as a Supreme Court possibility for the Supreme Court, has been very involved in the Federalist Society and so forth. He has come out very strongly in favor of the Harper position and has filed a brief. It's also interesting that there is an association of state Supreme Court justices. So this would obviously be a bipartisan organization where all of the chief justices of all 50 states are members. They don't usually take positions on things. I think I'm correct here. Correct me, Chris, if I'm not. And they have filed a amicus brief on the Harper side. So, but to be fair, there are plenty of state legislatures and state legislators who have filed on the Moore side. So it's quite there. There are dozens and dozens of groups and individuals that have weighed in on this case.
It's an impressive list indeed. I see that Bob Shields has his hand up. Bob, what's your question?
Yeah, I think we probably can figure out where Alito and Thomas are going on this. My question is, what is the background of Kavanaugh and Barrett? I mean, do we have anything in their legislature or jurisprudence history that would give us indications of how they're leaning on this?
So Justice Kavanaugh wrote a concurrence in the emergency posture of this case when the legislature appealed to the Supreme Court back in February or March, asking them to block the ruling from going into effect in 2022. And Justice Kavanaugh concurred with the denial of emergency relief, but wrote separately to say that he thought the issues were important and that both sides were making serious arguments that were worthy of serious debate. And so he expressed an interest in seeing a full merits case, so in the normal procedure with a petition for certiorari and full briefing and oral argument. He expressed interest in seeing a case presenting these issues sooner than later, and that just so happened to be the same case a few months later. With respect to Justices Alito and Justice Thomas, they both signed onto an opinion authored by Justice Alito at the same emergency stage of the litigation in the United States Supreme Court, saying that they thought the legislature had the better of the argument and that they would have voted to grant emergency relief. That said, they don't have the benefit of all the briefing at the emergency stage, and we feel very confident in the historical record that we're able to put together, in the explication of the case law that we're able to put together, and in the practical consequences that we're able to lay out for the court of just what it would do to adopt the independent state legislature theory here. So we go and argue, and we argue to all 9 justices when we make our case, and we'll see what we can do, but we feel good about the presentation that we're putting together.
Thanks. Any clues about Justice Barrett?
Justice Barrett hasn't written publicly as to these issues during her time on the bench. And so there's some references to opinions she's written in different contexts, in some of the amicus briefs in particular, but she hasn't written anything publicly with respect to our case.
Thank you.
I see that Ron asked in the chat about what are the actions that we can take to help support you in this case, and also I think in fighting gerrymandering generally.
For asking that. Well, we are going to have a rally on the steps of the Supreme Court on December 7th. So anybody that's in the DC area, we would love to see you there. And I think April is putting information in the chat about that. So we will be there from 9 to 12 on the steps. Personally, I'm hoping I get a seat, but the lawyers are saying that seats are very limited. So even with my name on the case, I'm not sure that I get to go inside. So anyway, we'll see about that. But I will definitely be in DC. We've got a hotel room booked for the night of the 6th. So we would appreciate your support. North Carolina, for better or worse, has been in the forefront of these cases nationwide. Common Cause North Carolina is the largest and most active local Common Cause chapter, and for that reason, and because of the ongoing nature of our purple state politics here in North Carolina, we tend to be at the focal point here. So you can support our work by donating, and you can and April's put information about that in the chat. That supports our Democracy Fellows. It supports our Speakers Bureau. It supports our staff. It supports all of the logistics around all of this organizing that we're doing now and in the future. And of course, you can talk about this case, because we feel that the more the public understands the stakes, the more people understand what's going on with this case and the implications for their own state, the better we are. There's lots and lots of national coverage. Google Moore v. Harper, and there's a ton of stuff. There's things that you can share. Bring it up in conversation, express your concerns. We're available to talk to your congregations or your other groups, and we appreciate your support.
Great. Ladorna had asked earlier about how we managed to lose the 2 Democratic seats on the Supreme Court. And I think, Becky, you explained about some of the background to that. But in connection with that, I'm wondering, does that affect this case at all? That it appears, if the case went back to the Supreme Court today, they might decide it differently. Does that in any way cause this case to be moot? Will it maybe encourage the Supreme Court to send it back there? And what does it mean for the future of gerrymandering in North Carolina?
Well, to be honest, it's not good for the future of gerrymandering in North Carolina. And that's why, the money and don't get me started on the ridiculousness of electing judges, but that's how we do it here in North Carolina. So anyway, it is very telling that the money to defeat these judges came from Republican pro-gerrymandering groups, the redmap.com. Now, to be fair, I think it's important that we point out that gerrymandering is a bipartisan sin. And while in North Carolina, we now have a legislature that's dominated by the Republicans, and even though our statewide vote again was relatively close in the last election, our General Assembly is 1 vote short of having a supermajority, of being able to override the veto of the governor. The governor can't veto gerrymandering maps, but the governor can veto the budget and rules about, legislation they might adopt about reproductive rights and education. And, we have knockdown dragouts going on about what's being taught in the schools and all the rest of it. So that is a huge issue for us going forward in North Carolina. Chris may want to weigh in on that question also.
Yeah, so there is an appeal that's currently pending at the North Carolina Supreme Court that has to do with the adequacy of the remedy that was entered in February. And so there is ongoing litigation in front of the North Carolina Supreme Court. We expect there to be a ruling in that second appeal soon, and where we go from there will depend both on the outcome of that appeal and on the outcome of Moore v. Harper. So there's a possibility for this case to continue going in any number of ways, and we will follow it where it goes.
Great. Well, I know we're getting towards the end of our time. Pablo, do we have time for one more question?
One more quick question, yes.
So Vivian, you've got your hand up. Would you like to ask a question?
Yes, I would. I feel bad though. Harry had his hand up first. So Harry, do you want to go or should I go? You're on mute.
My comment's really quick. The 2 judges who won those 2 seats on the Supreme Court have said publicly that if they had been on the court, in the spring, when that case came up, they would have approved, they would have allowed the unconstitutional maps to stand. So that's the kind of new justices we get. So Becky's right. We got just enormous uphill battle in front of us, and I don't know what our game plan is, but it's really a steep cliff to climb. So go ahead.
Okay, thanks, Harry. Yeah, my question is this. I live in California, and while I think many of my UU friends and myself are concerned about this, can you illustrate for us like the worst case scenario if this were if this case did not go our way in the US Supreme Court, so that I can get Californians excited about something that is happening in North Carolina and Washington, D.C.? Becky or Chris?
So I can answer a little bit and then I'll toss it to Becky. One of the things that the legislative leadership have asked for in our case is to overrule a very recent case from the United States Supreme Court just a few years ago called Arizona Independent Redistricting Commission. And that was the case that found by a 5-4 vote of the United States Supreme Court that it was constitutional under the Elections Clause for states to do their redistricting through an independent commission. And so the petitioners here, the legislative leadership of the North Carolina General Assembly, have suggested to the court in a footnote in their brief that they overrule that case and find that it's actually it was wrongly decided and that the Constitution does not allow for that sort of an arrangement. So California does do its districts by independent redistricting commission, and that would come directly home to how California does its redistricting. But again, it's something that not only matters in California or North Carolina, but it would dramatically alter the way checks and balances are set up for all 50 states with respect to federal election rules. And I'll toss it over to Becky to add some more on that.
So I grew up or spent much of my youth in Alaska, and Alaska, by citizen initiative, has adopted ranked choice voting. There's a lot of news about Alaska, and the Alaska legislature, which is predominantly Republican, is very upset about the results of the election in Alaska, and they have already been talking about getting rid of ranked choice voting, even though it was adopted by the people in a citizen initiative. The state of Nevada just adopted ranked choice voting in the election last week by citizen initiative. So all of these reforms nationwide are potentially affected by this case.
And with that,
Thank you. That's helpful.
I'm going to say thank you for our speakers and our audience. And I'll just add here, I mean, you have to sort of game it out a little further. Let's say the Supreme Court upholds this case in part, or even certainly in whole, but certainly even in part. You're going to see a lot of state legislatures exercising the capacity to overrule the courts, overrule the governors, impose their own maps, essentially engaging in what I'm describing right now as hyper gerrymandering, and then sending those folks to Congress, where California's caucus, large as it is, will be dwarfed by the number of caucuses from the other portions of the United States sending representatives to DC. So California, if you like the posture that your caucus has on federal issues, needs to defend their ability to engage in good public policy making by ensuring that they aren't overrun by candidates with white Christian nationalist, white supremacist ideology. And that's going to be a big issue now that certain members of the private sector have announced they're running for the presidency, and we are seeing some of those candidates filtering into the House. So this is a very real issue for all of us, no matter where we live in the United States. And with that, I just want to remind everyone that if you like this big frame conversation, to join us on December 6th